A very good day to Dr. Asma and my fellow friends. My name is Ka Yao, metric number 272807. Today our firm will explain 3 exceptions where a judge may depart from the rule that provides cause shall follow the event. In general, meaning of cause defined in Order 59 Rule 1 of the ROC will include fees, charge, disbursement, expenses, and remunerations. However, Order 59 Rule 3 subparagraph 2 is the exception for the principle of cause follow the event. In other words, the outcome of the litigation would be that unsuccessful party pays the successful party his cost and he is left to pay his own cost.
Good day, madam. My name is Amelie. My metric number is 272767. Today, I will discuss an exception to the principle of cause shall follow the events which pertains to cause arising from misconduct or neglect. According to Order 59, Rule 5 of the Rules of Court 2012, if any action or omission is done improperly or unnecessarily by or on behalf of a party in any cause or matter, the court has the discretion to direct that the cost incurred by that party in relation to such action or omission shall not be allowed to them. Instead, the court may order that the party responsible for the misconduct or neglect pays the cost incurred by the other parties. In simple terms, if the winning party in a case engaged in misconduct or neglect, the court has the authority to deprive them of the right to recover their own costs and instead require them to bear the costs incurred by the other parties. Factors considered by the court include failing to carry out action that could save costs, causing avoidable expenses, or unreasonably prolonging the proceedings. Now, I would like to pass the floor to my friend Nell Yazmeen, who will discuss specific cases related to this exception.
Kerajaan Negeri Johor and another against Adong bin Kuau is a good example to illustrate the cause arising from misconduct or neglect. In this case, the respondents sued the appellants in their High Court for violating their rights. The High Court awarded RM 26.5 million to the respondents as compensation. However, the learned High Court judge deprived the respondents of their costs without any reason. The general rule is that the winning party usually get their costs. Departure from the general rule is only allowed if it can be shown that the winning party misconducted in the proceedings and that he should not get his own costs. On appeal, there was no sign that the respondents had misconducted themselves to be deprived of the cost in the previous court. Thus, the Court of Appeal overturned the High Court's finding in cost and awarding the respondents the cost. The case of Hen Chow Lek against Tan Yu Lai is another example. The respondent sold the appellant a terrace house on installments and interest. The respondent then requested a new memorandum of lease, which caused the conflict in this case. The High Court awarded the respondent the house and certain monies owing under the agreement. The appellant then was to bear all the costs. So on appeal, the court shows that this matter would not have come to court if the appellant had cooperated. The respondent sent a polite letter explaining why a new lease memorandum was needed to convince the appellant to settle during the suit. Unfortunately, the appellant refused. The appellant's lack of cooperation to settle may have caused this litigation. Thus, the court cannot totally acquit him and the appellant should pay the High Court and Federal Court costs.
Assalamualaikum, a very good day, Abid to Dr. Asma. My name is Siti Nurhanis Suraya binti Sulaiman. My metric number 27K119. Moving on to the second exception, which is a party is successful on point not raised below. Accordingly, based on this exception, the court may depart from the principle if the party made an appeal. However, it must be noted that it is a general principle the appellate court does not interfere in the questions of cost as stated in the case of Petroleum National Berhad. Further, in Subramania, anak lelaki AJ Karupia's case, the court has established that it is a trial law the appellate court does not allow a new point that was not raised before to be raised and argued for the first time at the appellate stage, unless the court is satisfied that the evidence on which it asked to decide established beyond doubt the fact that if fully investigated would support the new plea. So the court would be a bit reluctant to interfere unless there is an error of law. So the operations of it is like when the winning party at the appeal won't get anything from the losing party by tendering a new evidence or new issue, as it would somehow act as a court penalty to him or her why she or he did not raise the issue earlier at the trial stage.
My name is Adriana, Safian, Mazni. My metric number is 273235, and I was talking about the case of Anna Jong Yu Hyong against government of Sarawak, where it basically illustrated these exceptions. So in this case, the plaintiff made an appeal against an award of damages by the High Court to the Federal Court. The Federal Court at the appeal hearing admitted an offer of coercions to the clean wage system suggested by the Safian Salary Commissions as a new evidence provided a new scale for the calculations of deceased loss of future income. It was held that the general damages, after all the requisite deductions, must be assessed at the 43,000, which was awarded higher than at the High Court, and they were to be allocated between the widow and her two children in accordance with the new salary scale. However, no costs were to be awarded to the appellant in this case because the appellant had won on an issue that was not brought up in the lower court. Hence, this is where, by omitting a fresh evidence in the appeal court and subsequently success in this case on point of not raised at the trial, forced to the exceptions of costs should follow the events. That's all from me. Thank you.
Good day, I bid to doctor and my fellow friends. My name is Koh Yuen Han and my metric number is 274056. Now, I am representing for the part of cause against advocate and solicitor personally, as it is one of the exceptions when a judge may depart from the rule that provides that cause shall follow the event. Notably, the legal provision that explains the personal liability of solicitor for cause can be found under Order 59, Rule 6 of Rules of Court ROC. In Order 59, Rule 6, Clause 1, it has listed the three situations where the court will order the solicitor to be liable for the cost. First is when the costs were incurred improperly. Second is the costs were incurred without reasonable care. Third is the costs were wasted by undue delay, misconduct, or default. Moreover, in Section 59, Rule 6, Clause 2 of ROC, it has mentioned that the solicitor will be given an opportunity to defend or convince the court regarding why the order should not be made before an order for the solicitor to pay personally. Next, the court was given the discretion of allowing or directing the Bar Council to attend and be part of the proceeding as long as the court opined that it fits. The discretion was granted by Order 59, Rule 6, Clause 4 of ROC. As referred to one significant case, namely Mitra and Co. and Teva and another, where the court decided that when there was a serious discretion of duty or gross negligence, then only the solicitor will be asked by the court to pay the cost personally. The most common example is that the solicitor has prior knowledge that the matter has no chance of success but still initiates it. But mere grounds like litigation fails or an error of judgment or mere negligence, the court will not order the solicitor to pay the cost personally. In light of Kapil Singh and Atif Ali, a decision was made by a Supreme Court where if a suit filed by a party is conspicuously unmaintainable, then the solicitor should be ordered to pay the cost personally. This judgment was granted because an application regarding the cost to be personally borne by the counsel for plaintiff was made by Kapil Singh, as the suit initiated by the plaintiff was conspicuously unmaintainable. The High Court disallowed the decision. The Supreme Court overturned the decision on an appeal. The clarification made by the Supreme Court is that the court plays an important role to make sure that the solicitor is acting in a good way, as the advocate and solicitor is an officer of the court. That is all from me. I'll pass to the next presenter.
In conclusion, it is important to note that there are three exceptions for the principle of cause shall follow the event, which is first, cause arising from misconduct or neglect. Second, the party is successful on the point not raised below. And lastly, cause against advocate and solicitor personally. So that's all from our firm. Thank you.